So I'm here to talk about what's been going on at the Maine Human Rights Commission and litigation updates for 2021. We'll start with the Human Rights Commission, and I will say at the outset that there were some tweaks to the Human Rights Act that came down the pike this year. I'm not going to touch those here because Anne Marie is going to be talking about those later on. So this is just kind of what's been going through the Human Rights Commission over the past year. Their annual report came out this past February. I just always think that this data is really interesting. Their total complaints for fiscal year of 2020 is up 8%. They had 775. In terms of their case types, employment, you're still keeping us all busy. It's leading the way at 69% of their cases, followed by housing at 15% and public accommodations at 14%. In terms of the employment cases, disability discrimination is the most common allegation at just under 49%, followed by retaliation of Human Rights Act at 39% and whistleblower at 31%, and it goes down from there. Now, of course, those numbers add up to more than 100%, and as you can probably guess, the reason for that is because in many cases, if not most cases, there's more than one grounds alleged. But I just find that interesting. So make sure you're really thinking through the interactive process and make sure you're very cognizant about potential retaliation claims, because that's where the bulk of these cases are coming from. In terms of how they've been processing cases, about 34% of their cases last year went through complete investigations with reports from the investigators. Roughly 65% of cases are being resolved before the full commission hearing. That's resulted in 196 settlements, 132 right to sue letters, 108 administrative dismissals, and only 23 withdrawals without any benefits being paid to the claimant. Overall, at the entire commission level, they resolved 238 cases. And this is where what I find really interesting about their reasonable ground rates. In cases when there was an investigator report, they found reasonable grounds in about 17%, give or take a little bit. That's up just very slightly from last year. When the investigator's report is contested, the reasonable ground rate is 26%. The overall reasonable ground rate for all filings, regardless of where it resolves in the process, is 6%. And the overall no reasonable grounds rate is 28%. In terms of hearings before the commission, they had 117 that were contested and 121 that went on the consent agenda. And they're very, very busy this year. As you all know, things have been backlogged a little bit. They have 742 cases pending at the end of their fiscal year, which is a 10% increase from the year prior. Their overall value of settlements for last year was a little over $4.1 million. That's a 42% increase from the year prior. I don't think that means that much additional money was actually paid out in settlements. My experience has been in the last year or so, the commission has been more adamant about wanting to know the dollar value of settlements before they will process withdrawal requests, particularly in cases that are dual filed with the EEOC, because the EEOC has been requiring that. So I suspect that this big increase is a function of more people are actually divulging that information to the commission. Their mediation program has a 44% success rate, and they conciliated 15 cases after a commission hearing with $61,000 and change in monetary benefits to the claimant. In terms of litigation, they filed 7 new complaints, 1 amicus brief, and they currently have 3 cases pending. In terms of case law updates, we'll start with the one that was probably the biggest talk in the state of Maine recently anyway, Doe versus Mills et al. This is the one that just went to the First Circuit recently, and this was the challenge to the healthcare vaccine mandate by Governor Mills that was filed by Liberty Counsel on behalf of a number of healthcare workers. And as you all have seen in the news, the lawsuit was trying to enjoin the COVID vaccine mandate, or more precisely to require consideration of religious accommodations for that mandate. The facts of the case are this. Maine has for many years had a law that requires healthcare workers to be vaccinated against a list of diseases. And historically, there had been three categories of exemptions. One was for medical reasons, one was for religious beliefs, and one was for philosophical beliefs. Vaccination rates had been declining for years. So in 2019, the Maine legislature actually eliminated the religious and philosophical exemptions. Then it went on to a people's veto, a referendum, and that was voted on, and 75% of voters in the state of Maine were actually in favor of eliminating the philosophical and religious exemptions. The change to that law technically took effect 2020. 2021, April of this year, the Maine CDC updates its regulations to reflect the 2020 changes. And then in August of this year, the Maine Department of Human Health and Services and CDC, excuse the typo there, issued an emergency rule to add COVID-19 to the list of diseases that require mandatory vaccinations, unless there's a medical exemption. The plaintiffs in the Doe case claim that they have sincerely held religious beliefs against taking the COVID vaccines due to the use of fetal cells in either the research or production of the vaccine, depending on which vaccine you're talking about. Their argument in the case was that this mandate is preempted by federal law, the First Amendment, equal protection, supremacy clauses, so on and so forth, and that it also violates Title VII. The First Circuit said that the plaintiff's First Amendment rights were not violated here in this case, the free exercise clause. And the analysis I thought was very interesting. A law that's neutral with respect to religion and generally applicable, that incidentally burdens the free exercise rights of your religion, will be upheld if it's rationally related to a legitimate government interest. A law that's not neutral with respect to religion or is not generally applicable has a higher standard that it needs to meet, and it will be upheld if it's narrowly tailored to achieve a compelling governmental interest. So one of the battlegrounds in this case is, well, which standard does this law fall under? Is it a rational basis test, or is it a narrow tailoring test? The First Circuit decided that this law passed either standard. In terms of a rational basis, they said that the law was neutral. It doesn't single out any particular religion or religious practices. And as evidence of the fact that it wasn't just targeting religion, they pointed to the fact that the philosophical exemption was also removed. The First Circuit also said that it's a law of general application. It didn't just burden religious conduct while exempting comparable secular conduct, and comparable is important because they said that a medical exemption is not really comparable to a religious exemption because the whole purpose behind the law is advancing public health, and making somebody take the vaccine if it's medically contraindicated for them does nothing to advance that public health purpose. Then they said, in any event, even if it were subject to strict scrutiny, it would still pass under that standard because stemming the spread of COVID is unquestionably a compelling government interest, and this law is narrowly tailored. And evidence of that was all of the other tools that the state has had available and that healthcare agencies have had available to try to combat COVID, masking, voluntary vaccination, PPE testing, so on and so forth. That hasn't been completely effective or as effective as it needs to be. And evidence of that is multiple outbreaks that have happened in healthcare facilities. So then the First Circuit said it doesn't violate the First Amendment rights, equal protection, that kind of goes away once the free exercise challenge fails. The supremacy clause, which says that federal law trumps state law, that was a straw man argument. Basically, the plaintiffs there were trying to make the argument that the state of Maine and the healthcare agencies that were named as defendants were claiming that the protections of Title VII don't apply in the state of Maine, and the First Circuit didn't give that much credence, nor should they have, because nobody was actually making that argument. The question was whether or not, well, we'll skip that. Anyway, moving on to Title VII, the Title VII analysis. This was at the preliminary injunction phase. So in order for the plaintiffs to succeed on getting the law enjoined on those grounds, they had to prove a number of things, one of which was likelihood of success on the merits, which for the reasons we discussed, the First Circuit wasn't sure they could do that. But beyond that, they have to prove irreparable harm, which is some form of harm that can't be appropriately remedied through money damages. And the First Circuit said that typically loss of employment or employment-related claims don't have irreparable harm. We get these cases all the time where people lose jobs, and their remedy is to get back pay, front pay, compensatory damages, all that sort of thing. So there might be a case where there's irreparable harm, but they haven't shown it in this one, is what the First Circuit said. In terms of next steps, the plaintiffs in that case moved for injunctive relief pending cert before the U.S. Supreme Court. That was denied by Justice Breyer, with Justices Barrett and Kavanaugh agreeing with him. And there was a serious dissent from Justices Gorsuch, Thomas, and Alito. So it remains to be seen what's going to happen here. But if I had to guess, I'm thinking that this isn't the last we're going to see of this case. A couple other cases to quickly touch on. Gonzales Bermudez versus Abbott Labs out of the First Circuit. This was an age discrimination claim and a retaliation claim based on a demotion. I've just been told that I'm long-winded here. I'm running out of time, so I'm going to move through this quickly. But the interesting thing on this one is that it talks to what you need for comparator evidence. They need to be similarly situated in all material respects. In other words, you have to be able to compare apples to apples when you're trying to prove discrimination by saying, look, this is what happened to other people or what didn't happen to other people, and I was treated differently. In this case, the two comparators had different jobs. They had different job duties. They had different supervisors. There was no evidence if they had any issues with their job performance. So the First Circuit said, we don't know enough about these people, and they're not similar enough to the plaintiff that we can't use them as comparators. And with that piece of the case gone, there's no evidence of age discrimination. The retaliation claim was based on a failure to promote after the plaintiff had complained about age discrimination. Basically, what happened here was she applied for a promotion. Everybody who applied had to do, and who was going to interview, had to do a mock interview or a mock presentation, excuse me. The employee refused to participate in that because she thought it was basically a done deal. They'd never take her seriously. And the First Circuit said it's not for the plaintiff to predict the employer's hiring decision and then claim to be the victim of that predicted decision. So by the fact that she didn't participate in part of the application process, she basically took herself out of the running to be a qualified applicant, and therefore she loses on that. Neto versus Twin Rivers Paper. This is a Maine case. This is a whistleblower case. I won't harp on this one because I have another one I need to get to. But the interesting thing about this one is the interplay between the Federal Labor Management Relations Act and the Maine whistleblower law. And the takeaway from this case is if you are unionized and if an employee makes a whistleblower type claim, if the case requires you to dig into the CBA to figure out, what's permitted under the CBA or what rights the employee has under the CBA, if you need to dig into that analysis to evaluate the whistleblower claim, the case is actually going to be preempted by federal law, and that needs to go through federal court, not state court. So that's what's interesting about this case. Two quick cases that I do want to touch on: Woodland Senior Living and Osmond Page. These both address Title 26, 599B, which Brent talked about earlier, which is the restrictive employment covenant, restrictive employment agreement, excuse me. Basically, both cases dealt with very similar issues with respect to those agreements. Number one, do these agreements apply in the context of a staffing agency? And number two, does it apply even if you entered into these agreements before the law took effect? In other words, by saying that we can't prospectively enforce a contract that we entered into previously, are you depriving us of our contractual rights? Is there a due process issue? In both cases, sorry to say, the law did not come out good for employers who want to enforce these agreements. Both judges in these cases said that 599B does apply to staffing agency and temp agency type arrangements. There's nothing in the law to suggest it doesn't apply to them. So for our staffing agencies or our temp agencies, I know that these are very common agreements that, basically I'm going to place my employees with you and you can't steal them from me and I won't steal yours. Unfortunately, 599B, at least as of right now, the case law is indicating it would prohibit that. So I guess the answer to that point is to get active in the legislature, use lobbying efforts, and get that law changed. Both judges also said that there's no retroactivity problem with prohibiting enforcement prospectively, even though these contracts were lawful when they were entered into. They said that there's no constitutional issue because the state has a very important interest in attempting to make it easier for people to work and not be restricted in where they're working. And these laws are narrowly or reasonably tailored to accomplish that goal. And it was just a reasonable basis test that the court used in both instances. And unfortunately, the end result of that is no constitutional contracts claim issue there. So even if you had these, they were lawful when you signed them, you can't enforce them going forward unless and until the law is changed or some other judge disagrees. But I don't think that's likely to happen. So that's the case law update.